Baker.
Lords, if I may, I'll begin with ground 2.
Yes, you may, of course.
That ground, like ground 1, was in terms cast by the court when granting permission.
Yes.
I make no further observation about that beyond the fact that on its face...
Some of us are innocent.
Well, perhaps
The
in
Supreme
relation
Court
to
won.
perhaps in relation to that, the rest of us can remain silent as well. On its face, it asks about the test. We say, clearly the correct test was applied. These are broad evaluative judgments to be reached. And on its face, there was no error as to the legal test. Indeed, none of the members of the Court of Appeal, Lord Justice Elias included, considered the wrong test had been applied. What Lord Justice Elias posited was that the correct test had been misapplied. Mm-hmm. Clearly, the question of the risk of harm to mental health was a matter for the review officer to consider. And that was what both of the review decisions were all about. But we hope this isn't cavilling about the precise terms of the grant of permission. Whether there was a real risk of such harm clearly isn't part of the test. One may say that in practical terms that might be, at least in certain circumstances, a helpful way of approaching it. But one does need to be careful here, as in other contexts, about supplanting or glossing the statutory language with other colloquial language. And it was for that reason that we drew attention to the fact that the broad evaluative nature of the judgments as to suitability and whether it was reasonable for the appellant to have accepted the offer should not be qualified. And we say that the application of Section 149 of the Equality Act doesn't affect that test in terms of what is required. And we've set out the reasons for that in our case. What the review officer did have to consider, we accept, was an actual adverse reaction to this property, whether or not it was objectively explicable. There's no part of our case that it could simply have been ignored. And we submit it's clear that the review officer did not ignore that possibility. Indeed, one has only to turn to paragraph 39 of the decision letter to see that the review officer specifically recognised the difference between objectively suitable accommodation and whether the property was suitable for this appellant, and also the question whether it had been reasonable for her to have accepted the offer. So it's clear we say that an appropriately person-centred, applicant-centred approach was taken throughout. And what we say happened here was a detailed investigation and consideration of all the circumstances, including what she said about her reaction, what her clinicians said she had said about her reaction, and about the types of property which the clinicians themselves were concerned about. And it's against that background that we then respectfully invite the court's attention not just to the decision letter, though clearly that is the main focus of attention, but to the entire process in which it came about, in order to see the context in which the review officer expressed his conclusions. And there are various features of that process to which we would draw attention. The first is that the viewing of the property was one in which the appellant was accompanied not only apparently by the friend to which we've had reference, but also by an officer from the housing association. And there is no suggestion at all of anything having happened of the dramatic sort that happened in the El Danui case, to which Lord Justice Elias referred below, and to which we have also referred, which you have in the first authorities bundle at tab 20. And what happened in this case? Mrs. El Danui was someone who had a fear of heights. She collapsed at the viewing and was taken to hospital. And it was against that background that the Court of Appeal in that case held that the decision on suitability had been irrational. But we are far removed from that territory. There is nothing to indicate that anything apparently amiss happened at the viewing. The first contact from anyone on behalf of the appellant following the viewing was 5 days later, when her support worker was in contact with the authority, and the court has the record of that in the core bundle at MS 397. The 21st of November 2012, in a telephone call, when, despite being aware of the consequences of refusal, the appellant had said she was refusing as she thinks the accommodation will be too small for her furniture. And it was only following that that we then had the letter to which my learned friend has referred at page 363, from the appellant asking for the review, and in that saying, as we see there, she found the property scary. The windows, plural, in the sitting room were circle-shaped and other windows were too small. Now, she accompanied that letter with supporting letters from her GP and the psychologist, and the court has those at pages 457 and 458. I shan't read them out. Your lordships will see what they say. The letter from Jennifer Baroni, the clinical therapist, dated from February, but the first letter did, but the second letter dated from the 20th of November, so at the relevant time, and over the page we have the GP's letter of the 26th of November. And these say nothing at all about the particular property which has been offered. These refer to something quite separate. And about the risk of using high-rise premises or premises with a lift. So the clinical medical information that was provided initially was, we would say, very substantially distant from the features of this particular accommodation, which was what the review officer had to consider. And so when Mr. Stack sent this material off to the council's medical advisor, it's not surprising, we would submit, in the reply that came back at pages 459 to 460, which the court has already seen, Dr. Wilson concluded at the top of page 324, there is nothing to suggest that this accommodation would be harmful or have a significant effect upon her mental health. It's an accurate reflection of the information available at that time. And so when the first review decision came to be taken, it's understandable again that the review officer cited that conclusion from Dr. Wilson. That paragraph 16, and the court has that at MS 407.
Yeah.
And what that decision also showed, so paragraph 16 follows after a recitation of some of the other response from Dr. Wilson. And over the page, paragraph 24, we see that there was reference by the review officer at that time to photographs that had been obtained from the landlord about the windows, from which the point was being drawn, well, this accommodation doesn't show features which create the dark and airless conditions, as he describes them. Nor are any of the windows small. So there was considerable attention at that point in the decision-making process towards the actual features of this accommodation and the material that the appellant was putting forward as reasons for her refusal. And up to this point, there was no reference at all to any panic attack in terms. The most we had was the letter seeking the review, saying that the appellant found the property scary. So it's against that background that we then have the letter of representations from the solicitors for the second review, which followed from the appellant having commenced an appeal under Section 204 against the first review decision. That appeal was principally or solely on the basis that the review officer had, it was alleged, not considered whether it was reasonable to have accepted the offer, as opposed to having considered the question of suitability. We say on the face of the first decision, in fact, it's clear both issues were considered first time around. The reason why the respondents compromised the first appeal was, as we've explained in our case, that they felt she hadn't had representation and she hadn't been interviewed. So it's with some interest that we see what the representations were that were made by the solicitors when they had the opportunity for the second review. And your lordships have already looked at those at MS 368. Yep. But this is some 9.5 months after the viewing took place. In the letter dated the 30th of August. And your lordships have already observed how some of the information in this letter is clearly wrong. But this is the first time, at paragraph 6, that we see reference to a panic attack, to use that term. However, supporting this letter was sent some further medical material, which is summarised on page 367, numbered 1, 2 and 3. And that is what your lordships have between pages 461 and 466, to which Mr. Westgate earlier referred. But what's significant in that information, respectfully, is first of all that the GP, Dr. Sharma, in the letter on 463, makes no reference whatsoever to a panic attack. What she talks about is the windows being small and round, having made her scared. And that seems to have more similarity with the appellant's very first communication, the letter seeking the review, which talked about property being scary. Secondly, what's significant, we say, about the letter from Dr. Sharma is the very last paragraph, with the doctor's view that the appellant should be offered the chance to view further properties that are not cramped or have small windows. Now, that's significant because the GP is identifying there what it is that in her view is significant in this case.
This is all plainly based on what she's been told by her patient. She hasn't seen the flat.
No.
So she's saying, this flat frightened my patient. My patient tells me that what it was about it that frightened her was X, Y, and Z. Therefore, any property with features X, Y, and Z is also going to frighten her.
Well, I entirely accept that this is on information. But nonetheless, this is all part of what the reviewing officer has to evaluate during the course of the inquiries.
She's the same doctor who read the letter on page 3458, the one of the
That's correct,
November 2012. Yeah.
the early one.
But what doesn't come out of this letter is that if, as a matter of reality, the description given to the GP proved to be inaccurate, then it would follow that the patient could not in fact have been scared by the property. And if her perception of it and therefore her description to the GP was not entirely accurate, that doesn't detract from the fact that it actually frightened her.
Well, but what has to be evaluated is to what degree was she affected and what are the features that may be considered to be causing that effect. So although this information, yes, certainly looks as though it was coming solely from the appellant, the way in which the appellant herself was describing it is clearly relevant. But as we have seen, she has apparently described it in a number of ways. And from that, also what is being evaluated is a sense of what the doctor's view is about the concern and the extent of it. Now, looking at, for example, 458 and 463 together, there are a number of separate concerns there that the doctor is identifying. Now, some of that will undoubtedly come from what the patient themselves describe, but one would expect that a doctor in these circumstances, who is expressing views about the appropriateness of different types of accommodation, is also bringing to bear in that exercise her own professional evaluation and trying to make sure that the relevant matters are being put forward. One could expect that a doctor treating someone with illness of this sort, including mental health problems, would have some expertise in being able to look beyond the mere fact of what it is that the patient is expressing. If the doctor is going on to express views of her own about what is appropriate. So it does go a little bit further, respectfully, than a mere account from the appellant, because this was being presented as a medical view from the doctor about certain types of accommodation. The letter from the therapist over the page 464 to 465 says nothing about the viewing at all. It states the opinion about being housed in accommodation with very small dark rooms without windows at a normal height, looking out onto everyday life, about the inevitability of that reminding her of the prison cell and the interrogation rooms. It goes on to make reference again to use of a lift. So
that's all perfectly true, of course. In her final sentence, she also says that if she, that's Mrs. Poshteh, were housed in accommodation which would be frightening and stressful for her, she might suffer a serious relapse.
But the therapist has not identified any other sort of accommodation than that described in the preceding paragraph that would give rise to concern. And it hasn't addressed anything about this specific accommodation. So one is taking, from the reviewing officer's point of view...
If the reviewing officer accepts that Mr. Poshteh was telling the truth, and the contrary hasn't been suggested, in saying that she found this flat scary, and if the reviewing officer accepts that housing Mrs. Poshteh in accommodation which would be frightening might cause her to suffer a relapse, can you just leave it at that?
Well, what the review officer has got to do, of course, is to consider questions of likelihood and degree. That is where all this goes in this broad evaluative exercise that has to be carried out. And what we're saying is that, important though it was, this information didn't carry a great deal of weight from the reviewing officer's point of view, because it wasn't addressed to the specific features of this accommodation. It appeared to be very general in nature. And it didn't say anything about what happened during the visit, during the viewing. And an important feature of this case, as being put forward by the appellant, is, well, I looked at the property and I had this reaction to it. But the information about that reaction is very scanty indeed. Been described in various different ways, and as we've seen, it wasn't information which came out immediately. Now, the review officer has to weigh all of that up, trying to get a sense of just how serious this is. And when he then interviewed the appellant, the notes of which the court has 427, 428. We can see what he does in terms of actually trying to identify what the features of this accommodation were to which the appellant took exception. And it seems to have come down really just to the shape of that one window in the living room. And it wasn't really about the light levels or the other windows, it was simply the shape of that window as it came down to it. Now that was a perfectly understandable inquiry to be making directly of the appellant in a sensible way, face to face, with a support worker present, in order to try and get to the bottom of what this was all about. And although it's also true, as we see later on in that paragraph, third paragraph on the page, that at the interview, the appellant maintained that she'd had what was described as a panic attack when she viewed the property. Again, we don't have any further detail about that, as to what that entailed. It is interesting to see what she then went on to say, as recorded at the very end of that paragraph. She stated she could not adequately explain how she felt to the officer from Notting Hill Housing Group, the Housing Association, who accompanied her to the viewing. In other words, that seems to be an indication that there wouldn't have been anything apparent to the housing officer who was there that was anything amiss. And it was only if the appellant had explained it that might have become apparent. And having conducted the interview, what the review officer then did, in fact, the very next day, as we see over the page, pages 429 through to 445, was to send the email, which your lordships have on page 430, attaching the letter at 429 with the plan and all the photographs. And in the email, as we see at 430, he invited the solicitors to make any further representations in relation to the enclosures. But there was no reply. So, having set out in their letter of representations on the 30th of August what they, the solicitors, understood to be the problem in relation to this particular accommodation, and having been sent really fairly graphic information as to what the property was like, it was then a case of radio silence. There was nothing that came back to say, well, we've taken instructions, we accept that it can't properly be described as this, but nonetheless we maintain the proposition that it was frightening because no information of that sort was forthcoming. So if we turn to the decision letter Mr. Stack then sent it starts at page 370.
Yeah.
It has a very long recitation, long and detailed recitation of the history of this application. From the beginning through the first review decision, with the medical information that was provided along the way, then through the further representations made by the solicitors with the supporting medical information and details of the interview. And tempting though it is to look at paragraph 45 in isolation from the rest, because that is what has really excited the attention in this case. One can't fairly read that without looking at the entirety of the process which led up to this, and the discussion that flows throughout all of this about the issues of mental illness and the impact of that both on suitability and whether it was reasonable to accept. And although paragraph 45 comes where it does in the analysis, following immediately on from the discussion about the matters set out in the medical information, it's necessary, we would submit, to consider that also in the light of what follows on, which is further consideration of the parallel questions of suitability and reasonableness. Not as though the medical aspect of it is to be considered entirely in isolation from the rest. And we would say there's nothing to indicate in any of this that the review officer has disregarded what the appellant said was her reaction to this property, which has really become the focus of this case and was the substantial matter on which Lord Justice Elias differed from his colleagues in the court below. Has it simply been cast aside, what the appellant said was her reaction, on the grounds that it's not explicable reasonably? And we would say there's nothing to support that reading. It's clear throughout that what was being contended for by the appellant was being given very detailed consideration. The difficulty was in trying to come to a clear conclusion as to what she was saying, bearing in mind the different ways in which it had been put. But even looking at paragraph 45 in isolation, respectfully, we would say, very much in the same way in which Lord Justice Moore-Bick looked at it in the court below in his paragraph 62. There were really two propositions in the first sentence of paragraph 45. One is the rejection on grounds of objective reasonableness of the assertion of a reminiscence between the prison cell and the size and design of the windows in the living room. And secondly, the rejection as being not objectively reasonable. The proposition that the windows or layout were such as to recreate the conditions likely to have a significant impact on her mental health. The second part of that, therefore, is a composite conclusion, which embodies consideration not only of similarity, but also the question of likelihood of significant mental health impact. And we therefore say there is nothing in that paragraph on its own, let alone in context, to indicate that either the wrong test was applied, or, to put the matter slightly differently perhaps, to say that relevant considerations were ignored or disregarded in terms of what the appellant asserted her reaction to have been. Beyond that, we say it wasn't necessary for the review officer to make any more detailed findings of fact. This wasn't a trial. What the review officer had to do was to come to a broad conclusion. And there are various permissible ways of doing that in the context of a case like this. It did not require, we would say, although it would have been open to him to have done this if he so chose, to have gone into a more detailed evaluation as to what he accepted and what he didn't in terms of the appellant's account. But it wasn't necessary to do so, we would say. At this point, could I take your lordships very quickly to two cases, the first of which is in Authorities Bundle 10 at tab 17. It's actually one of the authorities that Mr. Sheldon relied on.
Right?
But it's a relevant illustration of what happens in these cases. So this is Sheridan and Basildon. This was, in fact, a case about gypsies, and the appellant's refusal of what's often described as bricks and mortar accommodation instead of a traditional caravan or something of the like. But at page MS 907, in the judgment of Lord Justice Patton, at the foot of the page, paragraph 49.
Yep.
Talking about suitability and having referred earlier to Codona, which we've also mentioned.
Yep.
He says no absolute standards to be applied. Obviously, be exceptional cases where the degree of impairment will be so serious that nothing can justify it being treated as suitable. And he refers to Omar as being such a case. He goes on to say, but at the other end of the scale, the risk, e.g. of depression, may be slight and the consequence is easily contained. He then refers back to the judgment of Lord Justice Longmore, from which he cited at the previous page in Lee and Ronver, who said he didn't regard the possibility of psychiatric harm as sufficient to take the accommodation below the Wednesbury line, saying in principle, I agree with this, obviously in a particular context there. But here we have recognition of a broad scale to be applied in terms of suitability. There is this Wednesbury minimum that has been recognised consistently in the case law, but it will take a good deal to reach it. Now, it was reached in Eldenouy, the court said, where the appellant physically collapsed at the viewing and was taken to hospital. There may well be other circumstances where it's to be regarded as being sufficiently serious. But in many other cases, it won't have reached that level. And we're not here presented with a challenge on the basis of irrationality of the conclusion. We're based much more with a challenge that's focused around the reasons and to some extent the inquiries. Now, one of the points which my own friend makes in terms of the medical evidence was, well, you didn't conduct a further inquiry to find out whether the doctors might have said, well, notwithstanding what we said about the types of accommodation we were concerned about, we would be concerned too about the accommodation which has been offered because of its characteristics. But there must, with respect, be a limit to the extent to which such inquiries have to be made. We've cited towards the end of our case a number of authorities in relation to the extent of the inquiries that arises. But in the most immediate context here, we're not, of course, concerned with the first decision that's made, where the applicant has just presented, and so necessarily the onus is going to be on the authority to make inquiries as are necessary to satisfy themselves. Here we are concerned with the review process, indeed the second review process that has been carried out. So this must be the very end of the entirety of the process from an administrative point of view. And having got through the stage where in the first review decision the review officer has said, well, there's nothing in the medical material to indicate concern about a property of this sort, to suggest that the local authority then need to go back and make further inquiries, having had further representations from the solicitors, accompanied by further medical material, and been offered the opportunity to make further representations, having been shown a diagram and photographs of the property. When all that has been done, fairly the duty of inquiry has been exhausted. It's not to say that further inquiries couldn't be made. The question is, was the local authority required to make further inquiry? And we would submit that they were not. And on that point, we can perhaps also helpfully refer in the third bundle of authorities at tab 48. This is the decision of Mr. Roger Henderson, Queen's Counsel in Islington ex parte Thomas. Within which the question of suitability on medical grounds arose. And at page 1181 in the bundle, the last full paragraph on that page, continuing over to the top of the next page, was the conclusion in relation to the medical evidence that had been provided by Professor Littlewood. Where the point was made, well, the doctor could have said more about the particular difficulties in the case, but his words fell far short of having done so. So there is a practical...
Sorry, where are we reading from in this case?
So in the last paragraph on foot of page 1181 beginning, although the subsequent interchange leaves matters open to debate, 5 lines down.
Yeah. Well, that's the case on its facts.
Well, he could have gone further. And that was a similar position in this case, that if the medical evidence really did support something specific in relation to this particular accommodation, one might well have expected that it would go a lot further than, as we see, the clinicians did in this case. And so when we're looking at the review process in particular, after a decision has been taken, the initial inquiry duty has been exhausted, the applicant puts forward reasons for seeking the review, in this case has put forward representations through solicitors supported by the medical information. The review officer can hardly be criticised for taking that at face, considering how far does that go, particularly against the background where the decision-making process has already pointed out to the appellant and her advisors the lack of correlation between the sorts of premises that the clinicians are saying are to be avoided and the features of this particular accommodation. So, respectfully, we say there wasn't any further inquiry which the review officer should have made in terms of the medical material. And we also submit, respectfully, that it's too simplistic to say, well, the review officer never challenged the appellant about the panic attack or denied that she'd had one. It wasn't being denied that she said she'd suffered some sort of reaction. The difficulty, as we've seen, was in trying to identify what that really amounted to. And what the review officer did at paragraphs 41 to 44 was a very careful analysis of the difficulties in the information that was being put forward. And that then provided the foundation for what we see at paragraph 45 against the background of the whole, including all the other reasons why he found this accommodation to be both suitable and following from an offer which it was reasonable to accept. Public sector equality duty, we respectfully say, doesn't add anything of any substance. Lord Newberger will probably be tired of that submission on the back of HOTAC, but one's faced with a very similar position in this case, where the Section 149 duty can be described as being complementary to the functions under Part 7 that the review officer had to carry out.
Yeah.
And we've made our general submissions, so far as they fall to be considered, about reasons and inquiries towards the end of our written case. One of the considerations has to be that the court shouldn't, we would submit, seek to impose unrealistic expectations in terms of what these review decisions will contain. And that was a theme through a number of cases, including Holmes-Morehouse. Finally, on this point, we would respectfully disagree with my learned friend in his proposition that in some way the Court of Appeal, or the majority of the Court of Appeal, went beyond their proper remit and, as it were, reconstructed the decision. Necessarily what they were doing was trying to evaluate the argument that was being put forward and to see whether the review officer's decision could stand. Because it is generally recognised on these appeals that it's, on the subsequent appeal, it's not a question as to whether the court below has got it right, but whether the initial decision was one which can stand. And when one analyses paragraph 45 in the context of the decision-making process as a whole, we say it can stand, and that was the exercise which the Court of Appeal was carrying out. It is, of course, permissible under Section 204 in any event for a court to vary a decision. The powers of the court are to confirm, quash, or vary. So this is a slightly different jurisdiction in some respects, because in that very limited degree, the court can change what the decision maker has done, but it's generally recognised that that arises in circumstances where there is a very likely conclusion which could have been drawn, which the court feels able to draw and accordingly to vary the decision however it may be. So, my lords, those are our submissions on ground 2. We would invite you to reject it.
Right.
If I can turn to the Article 6 point very quickly.
On that, I understand you adopt a neutral position on the point, which as to whether it applies, but you say it makes no difference.
We do.
Right.
And it's important, we would say, for the court to have both arguments before it, for all sorts of probably self-apparent reasons.
Yep.
There are really 6 points that we would rely on.
Right.
The first is we say there's no authority at all for my learned friend's proposition that the mere application of Article 6.1 results in any change to the approach of the court, either under 204 generally or in relation to questions of discharge of duty.
Right.
Nor would we say is there any support for the proposition that somehow the grounds of appeal have been or would be extended. To the contrary, we say the position remains as set out in Runa Begum, and in particular...
This is your first point still?
This is the first point.
There are 5 more, right?
I'll take them very quickly, my lord, I promise. We refer to Lord Bingham at paragraph 7 and Lord Hoffman at paragraph 17 in Riuna Begum,
Right.
which is at Authorities 1 tab 18.
Thank you.
And we say the nature and extent of the court's review powers was part of the ratio in Riuna Begum. It wasn't something separate.
Right.
Allied to this self-same point, we would say, is that there's nothing in Ali in the UK to alter the position.
Right.
To the contrary, there's a long passage from Lord Hoffman in particular that's set out at paragraph 36, where he talked about conventional judicial review. The grounds that the European Court envisaged being sufficient are set out at paragraph 83 of its judgment. They're all conventional judicial review grounds. And at paragraph 87, the court concluded that the authority's decision was, quote, subject to judicial scrutiny of sufficient scope to satisfy the requirements of Article 6.1.
Right.
And this court, we would say, should keep in step with Strasbourg. Secondly,
Yeah, and that might be thought to have been a stronger case than this one, in that it was a pure question of fact.
Well,
either she'd have received the letter or not.
absolutely. And that is one of the features, that where there is a hotly disputed question of fact, one may expect the court to inquire very closely as to what the position is.
Yep.
Secondly, we say that what both Riuna Begum and Ali in the UK establish when considering compliance is not any discrete issue, such as question of fact, but the entire scheme under Part 7 as a whole. And there are 4 elements of this scheme, which we would say together embody what could be described as a classic exercise of administrative discretion, to use a term to which Lord Hoffman referred in Riuna Begum.
Yeah.
The first is the relatively unspecific nature of the assistance to be provided, to which enough has been said already. The second is the highly evaluative and judgmental character of many of the matters which the local authority may be required to make decisions on. Therefore, Mr. Sheldon's already referred to some of those, but the question as to whether it's reasonable to continue to occupy is embodied in the very definition of homelessness itself in section 177. The question of vulnerability is very evaluative, of course, and the questions under 193, which we see here, are further examples. The 2 other aspects, however, that could also be relied on are the relatively specialist nature of the subject matter, because the local housing authority are empowered, for example, to have regard to the general circumstances prevailing in their district when considering whether it's reasonable to continue to occupy under section 177. Now, those are going to be quite detailed specialist matters. And finally, the scope of the inquiries to be made are, by reason of section 184, such as are necessary for the authority to satisfy themselves. And this, of course, is one of the foundations for Lord Brightman's dictum in Pulhofer, that the extent of the inquiries, and indeed the result of them, is very much a matter of administrative discretion. The third element are the procedural safeguards, which are referred to at some length in both Riuna Begum and Ali in the UK. And then the other points that we would make in relation to compliance are these. Even if the section 193 right should be a civil right, it nonetheless remains, as Lord Walker described in Riuna Begum, at the boundary of what Article 6 would be capable of comprehending. And the fact that it lies at the boundary underlines the importance of the flexibility which has been recognised in terms of the particular requirements needed under Article 6. And that flexibility, we say, is as important now as it was at the time of Riuna Begum to avoid this difficulty about over-judicialisation and emasculation of administrative schemes. The fifth point we would make, just reiterating the discussion earlier with Lord Reid, is that these concerns aren't confined to questions of primary fact-finding. Indeed, one could say that there is room for even more concern about judicial intervention in the evaluative parts of the exercise than there is about the fact-finding part. And finally, that brings us to the question that the Strasbourg Court described in Arley at paragraph 84 as the policy objective pursued by the underlying domestic law. And that has to be seen, we would say, in the context of discussion of statutory and administrative schemes which are founded on the notion of expediency. This is all bound up with the extent of the administrative role as opposed to the judicial role. But the concern here is this balance between the issues that may arise in a particular case and the balance that has to be maintained across the piece between all applicants. And the European Court in Arley talked about a multitude of small cases intended to bring as great a benefit as possible to needy persons in an economical and fair manner. And we can put some colour to that resources argument, if we may.
Yes, you can shortly. I mean, you're now overrunning by 10 minutes.
I'm just about to finish, if I may.
Right.
In 2015-16, the respondents alone received 1,080 applications under Part 7, which led to acceptance of duty in 498 cases.
Yep.
And as figures published by the Secretary of State's Department show, in 2015-16 as a whole, the annual figure for London authorities is over 33,000 applications. Nationally, it was over 120,000 applications made under Part 7. And at the end of September of 2016, those same statistics show that over 53,000 households were in accommodation arranged by London authorities under Part 7. Nationally, it was over 74,500. So we are talking about large numbers of applicants.
Yep.
And in terms of reviews, the respondents undertook 314 in the year 2015-16. 133 of those involved suitability. And at the beginning of December, they had 72 ongoing reviews. At any one time over the year, they have something between 60 and 90 going on, and they employ 4 full-time officers in order to deal with that workload. So the impact in terms of resources on the decision-making part of it is a very real concern. Alongside that, however, is also the cost of accommodation being provided, meanwhile, because so far as applicants are in accommodation pending some final offer by way of an allocation, they're in accommodation which is significantly more expensive. To put that into some sort of context,
Yes, you said you were about to finish. Make it fast, please.
I am, but the cost of the temporary accommodation that is being provided in this case, and which would have to be provided in many cases pending inquiries, pending review, pending appeal, is significantly greater than if these people were actually accommodated in ordinary social housing. In some cases, it may be as much as twice as expensive. So the resources argument also comprises the cost of that. And then we have the cost of the legal process, which on average, for an appeal, costs this authority, under their own internal costs, in excess of £2,600 per appeal. Leave aside what they may incur if they're unsuccessful. So those are the practical resource considerations which are of concern to this and other authorities. Lord, I'm sorry if I've trespassed on time further than I should.
Well, you just estimated 50 minutes, and you've been 60.
Those are finally, I'm pleased to say, my submissions.
Thank you. Thank you very much.
deal first, if I may, with the points on the review decision. Mr. Baker has explained to you a good deal about the background to the way in which the decision was arrived at. But what he's done, with respect, is the same, or falls into the same category of error as we say the Court of Appeal decision does. In that what he's done is he's pointed to various factors that he says might have supported the reviewing officer's approach, or might have supported his decision. For example, he's drawn attention to the fact that the panic attack first was mentioned to the authority, they say, some 9.5 months after the viewing, and matters like that.
You say I'm not saying you're right, but you say he's defending a decision which was not the decision that was made.
Exactly.
Yeah.
And if I can ask my lord to turn to the authority that both sides seem to pray and aid, which is the Holmes-Morehouse case. It's tab 23 in volume 2.
Yeah.
My lord, there, paragraph 51, which is page 770, sets out the circumstances in which a decision can often survive, despite the existence of an error in the reasoning advanced to support it. For example, sometimes the error is irrelevant, sometimes it's too trivial, sometimes it's obvious in the rest of the reasoning, read as a whole, that the decision would have been the same, notwithstanding. Sometimes there's more than one reason, and the error only undermines one, and so on. Sometimes the decision is the only one which could rationally have been reached. In such case, the error should not, save in perhaps exceptional circumstances, justify the decision being quashed. Now, none of those apply here. This isn't a case where it's obvious from the rest of the reasoning. It isn't a case where there are two reasons given, one good, one bad. And it's certainly not a case where it's being said that there's only one possible answer. What one has, in effect, is not a case of mixed reasons in this case. What you've got is a case of the only reasons being given by the reviewing officer when you come to consider what is actually informing his decision in paragraph 45 is the lack of objective similarity. And that's, one can see that from the terms of the letter, and I'm not going to take you back to it. But one also finds the point picked up in the way in which the investigations proceed. Because Mr. Baker said, well, it's for the reviewing officer to evaluate the way in which to evaluate the severity of the panic attack. And he said, well, there was a good deal of information surrounding the way in which the panic attack was reported that might have caused the reviewing officer to take the view that it was less serious or not so serious as to justify turning down the accommodation. He relies on the Sheridan case. Now, I, of course, accept that as a proposition, that a reviewing officer isn't bound to say that any kind of medical condition will lead to accommodation not being suitable. But the background here is there's no hint of that in this case. The way in which the letter was written appears to have been on the assumption that if there was exposure to an inciting stressor, then that would render the accommodation unsuitable. So there's no suggestion on the actual reasoning that this isn't something that's sufficiently severe. But moreover, one doesn't get it in the interview. If the point was going to be taken, well, this can't have been that serious because you didn't mention it earlier. It can't have been that serious because you didn't put it to your GP. Those are exactly the kind of things that you'd expect to be picked up in the interview, and they're not, which suggests that the decision maker isn't focusing their mind on the right question, because the focus of inquiry there is all about objective similarity. But it also feeds into the nature of the investigative duties in this case, because there is a duty to act fairly in the course of the investigation. If the reviewing officer is going to rely on those kind of things, they're the kind of things one would normally expect to be put. If they're going to be part of what the reviewing officer relies on as part of their decision, the applicant's entitled to have them set out on the face of the decision letter so that they can challenge them in the county court if there is a ground to do so. And none of those things happen here. And so I'm not taking simply a formal point that these are things that don't turn up in the decision letter and therefore they shouldn't be recorded, or they shouldn't be relied on. The point I'm taking is that it is more fundamental than that, that there's very good reason why one shouldn't allow additional material of that kind to be put in. I raised the blurring the boundary between decision maker and court, but it also has profound implications for fairness. So it's the exercise that has been suggested to you, attractive though it might appear, is one that's simply not permissible, and it's not authorised on the authorities, whether the reasons come from counsel or whether the reasons come from the Court on Appeal. The reasons you should be focusing on are those given by the reviewing officer. The point is taken, well, this is an overall evaluative judgment that has to be made, and one shouldn't be too exacting about the way in which the reviewing officer goes about it, because there are various different ways in which the reviewing officer might come to the conclusion that this is not something which is of sufficient severity to justify the property being refused. At one level, that's simply the same point repackaged. What is being said is, well, there are other reasons that the reviewing officer might have referred to, and therefore there's every reason to give them the benefit of the doubt and assume that those were in their mind and that they justified the decision. You already have my submissions on that. But there's a further point about the quality of reasoning on that. And that's a case where, if I can ask my lords to turn to volume 3, tab 40. It's a case, Mohammed and Islington. And it was a priority need case where the applicant was someone who was prone to fainting spells that she'd come round from spontaneously. And much the same point is being made against us, was made by the authority in that case. Yep. And if I can ask my lords to turn to paragraph 18, page 1094.
Yes.
And it's paragraph 18 for the proposition about one shouldn't be distracted by a detailed and lengthy letter and the risk of losing sight of the wood for the trees. But then one goes on to the paragraph 20, that the proposition is that Mr. Arden submitted this formulation as simply one way of approaching the question, which is a composite one. And that's the point that's being made here. The term composite was used. It involved the exercise of a judgment, and the reviewing officer, using a very considerable experience in this field, shouldn't be prescriptive as to the manner in which the reviewing officer approached the overarching vulnerability question. And then paragraph 21. The decision's a composite one. It involves the exercise of expert judgment, and moreover, the court shouldn't be prescriptive as to how the reviewing officer approaches it. But it seems to me, on the facts of this case at least, however the composite questions be approached, at some stage in the reasoning process, any reasonable reviewing officer would have to have asked him or herself the two questions that were identified by the judge. It was necessary to decide how being homeless would affect the medical condition in question, so that one could then decide whether an individual with that medical condition, when homeless, would be less able to fend for him or herself. And Lords, the same applies here. It's simply not good enough on the facts of this case to say, as paragraph 45 does, in a very general way, and in a passage which is fairly opaque in its reasoning, well, I'm not satisfied with your assertion. I won't repeat what it says. When what lies behind that is a very clear factual question, which is what's going to happen, what is the risk, and how is that being evaluated? And lying behind that, there are also various points about the panic attack and so on, which I won't go back over. But the critical question was one of fact, which simply isn't addressed in this decision letter in the same way that it's not addressed in Mohammed and Islington. And it's a useful illustration, we say, of the way in which one simply can't rely on a broad formula to have wrapped up all those fact findings where the discipline of telling the applicant why she has lost demands more. And as I said in opening, what was demanded here was an explanation to the appellant as to why it was that the actual panic attack she had and the actual reaction she had to this property was in some way to be treated differently from a reaction that would happen to somebody, to her, had the similarity to a cell been objectively justifiable. We support that reasoning by reference to the PSED, but I'm not going to go back over that. The point was taken that there was no obligation in this case to make further inquiries, and the point was taken that, well, the doctor didn't expressly say that this accommodation was unsuitable, and there had been a chance to comment. What the respondent can't get away from on that is that what they can't do is say, well, that on the face of that evidence, then use the evidence, or rather use the absence of evidence, to support a proposition that it simply doesn't support. It may well be that there comes a point when you don't need to investigate any further, but one is still left with the evidence you have, and you have to understand that properly. So that's the first point. But secondly here, the evidence did raise the critical question. And it doesn't matter how many questions have been asked on the way. It doesn't matter how long the investigation's been. Ultimately, the reviewing officer has got to carry out enough investigations to satisfy themselves. And there was a gaping question here, which is what would happen to her in this property. And you can't answer that against the applicant on the basis of an assumed and questionable reading of the GP's letter without making further investigations. Can I bear with you there just before I move on to the Article 6 points? Is there anything else we need to do? Well, there's before I finish on this point, I should refer to because it hasn't been raised specifically by Mr. Baker in his oral submissions,
Yep.
but it is referred to in the paragraph 85 of their case, page 215. It really follows on from the point I made about Holmes Morehouse and the effect of being able to support a decision by looking at the material overall. And they rely on Dinesh and Bubb. But both of those cases were ones where the dispute was in fact a rationality challenge.
Right.
And so they're not quite like this.
Thank you.
If I can move on then to the Article 6 point, dealing first of all with the application of Article 6.
Yeah, maybe, as Mr. Sheldon argued, basically we shouldn't follow
No, indeed.
the
And
decision in Strasbourg for the reasons he gave.
we
We should have a dialogue situation.
yes, well, there's a practical disadvantage with the dialogue, which is that it's quite a slow dialogue, in that I think it was something like 5.5 years after the decision in Alley and Birmingham that we got the decision in Alley in the UK. And so if the dialogue is going to proceed at that pace, then it may have little advantage. But what we say is that the
Yes?
basis that Mr. Sheldon has suggested for not applying Article 6 doesn't come anywhere near the sort of Horncastle proposition that Strasbourg hasn't appreciated or accommodated particular aspects of domestic law. There are three general points I make. Firstly, that the trend in Strasbourg is one which is an expansive one, and that can be seen in various sources. If I can, without turning it up, Lord Bingham in Begum, it's paragraph 6 at page 653, said the trend is of a move from a narrower to a broader interpretation of civil rights.
Yeah.
It's also something which is being commented on in some detail in an article, which I'm not sure you have, but from Mr. Baker, in fact, in the Journal of Housing Law that deals with this, and I put it to you simply as a useful summary of the development of the case law.
So you say we haven't got it?
I think you do have it. I wasn't sure
Which
whether it had
one
been
was
passed
it?
up, but it's not in the bundles. It's a new document that will be loose. It's marked in yellow, apparently.
Oh, this one, yeah.
Yes,
Okay,
I'm not going to ask you to go to any particular...
We do have it, yes, by Mr. Baker.
Yes, but...
I should say I wasn't asking for your lordships to read it.
Well, this seems to talk about clutching at straws in the wind.
Yes, but the...
Anyway, okay.
Anyway, the second general point I make is that the expansive approach has been one to extend the protections of Article 6 to welfare benefits generally, and that follows through a series of cases, in particular in Salesi, which I think you do have, which is marked, again, it's not in the bundles. I'm afraid these are authorities that all come out in response to the Secretary of State's argument, and so I'm afraid haven't found their way into the bundles. But Salesi in Italy was a case which involved...
Well, this is all in Mr. Baker's article, isn't it?
It is. The reason I draw your attention to it is one point, that if one looks at paragraph 11, or 10 and 11, one's got the relevant domestic law set out there,
Yes.
and one sees the nature of the discretion that was in issue in that case, or the nature of judgment. But paragraph 11 showed that it was a disability allowance to disabled servicemen who are two-thirds disabled, which is a bit like the Schuller's-Graben point, but also who are destitute. And of course, destitute raises the sort of judgments that one has in Part 7, particularly if one's thinking about reasonable to continue to occupy. There's also a passage that I'd refer you to in the opinion of Mr. Spadutti, at page 195. It's the end paragraph, so it starts at the end paragraph of 194. The evolution is important in several respects, foremost among which is the fact that it's entirely congruous with the approach to human rights adopted by the Institute of International Law. And then the next paragraph says, hard to see how it can be held to be guarantees of fair trial set forth in Article 6 don't extend to disputes over rights which the domestic legal system grants persons in distress, precisely on account of their inherent dignity as human beings. The reason I mention that is that it ties in with a point made by Lord Millett in the in Begum, and the reference to that is Volume 1 at paragraphs 87 and 93. And if I can ask you just to turn those up, it's Volume 1, tab 18.
Yes. Yep.
And if I can ask you to turn to paragraph...
Paragraph.
It's paragraph 93 is the...
Yeah.
I'm sorry, my Lord, it's the wrong paragraph. Paragraph 87, it's page 674. It says, picking up the second sentence, the process has been a gradual one. Underlying the process, there must, I think, have been a desire not to restrict the guarantees of fair hearing. But Strasbourg court's not, then there's the reference to not proceeding by reference to principles. So the point is, and then one comes to paragraph 93, where he says that it's not difficult to conclude the nature of the dispute in her case makes it inappropriate for determination,
Yeah.
but more difficult to justify withdrawing it.
Yes.
And that's something which is cited by the ECHR and Ali, and it makes the point, which we say is a corrective really to Mr. Sheldon's floodgates point, which is that if you cut off the right at source, as it were, then in respect of important entitlements, as far as Strasbourg's concerned, you don't have any procedural rights at all, other than those that might be given to you by the substantive articles if they have a procedural content. Whereas the judicialisation concerns, which are real and we accept are important, are ones that can be and have been dealt with by recognising the limitations on review by a court of full jurisdiction. So those are the three general
Where does he
points.
get his point that most European states possess limited judicial control of administrative decision? I find that a bit surprising.
It's,
It may not matter, but it does. I wouldn't want to necessarily to accept that without.
it's something that is, I think, referred to in. I'm afraid I can't put my finger on the reference, but
Well,
certainly
don't worry. It's
I've
just,
written down don't know in answer to that.
don't know, I think is the answer. Well, I don't think it's critical to this.
no, but it's a reference to limited administrative courts in many European
Well,
jurisdictions.
it is, yes,
Review
that's
on the
self-evident.
basis of-
But most of them have very well developed administrative law system.
so, for example, I think in
distinction between-
Obermeyer in Austria, there was a point about the constitutional court and the
Yes, perhaps it's what you mean by court. I think.
yes, but it's the ones that fall into administrative law.
Yeah, okay.
So those are the three general points. So far as the substance of the point goes, the thrust of Mr. Sheldon's submission is that Strasbourg didn't recognise the breadth of discretion, in particular,
Yep.
didn't recognise the breadth of discretion that has a financial or resources-based content.
Yes, yes.
To which the short answer is that may all be so, but what it doesn't do is take away from the fact that the right does have a flaw. And what gets enforced is the minimum content of the right, and that's the nature of your right. And the reality is that the most telling term used by Mr. Sheldon in this part of his submissions was when he talked about authorities having a choice. And of course, authorities may well, in some circumstances, have a choice. And when they have a choice, then they can choose whether to make the most expensive choice or whether to make a least expensive choice or something in between. But the very fact that they've got a choice means that they are making an election between options that are above the bare minimum. And the bare minimum is what one has to look at when one's talking about the duty. I mean, in that respect, the position of the authority is no different from any other contracting party who has got a choice as to the way in which they perform a duty, say, under a contract. In those circumstances, they can choose the means of performance that's most beneficial to them. And no one says in those circumstances, well, the duty doesn't exist because there's some kind of evaluation, nor would they say that if the evaluation happened to be exercised by a public body as a contracting party. So the exercise of that kind of judgment simply can't prevent the duty existing, and it certainly can't prevent the right being a right. All it may mean is that, as a matter of content, as a matter of domestic law, the right may be restricted to the minimum of what one would have to say is not suitable. But that's the answer to the point.
We have the point.
And there's no suggestion that Strasbourg was unaware of the amplitude of the discretion.
Yes.
So that's the point about the application of Article 6. As far as the amplitude of judicial review is concerned, it's a point that we accept hasn't been expressly dealt with by any of the authorities. Begum was a case which dealt with the scope of judicial review,
Yes.
but in comments that we suggest are obiter. Our point in relation to this, it really comes down to 5 propositions. Firstly, the logic of the Article 6 cases demonstrates that it can, in principle, regulate the intensity of review.
Yes.
Secondly, what's ultimately required is whether there's been a sufficient independent investigation into the issues. Thirdly, traditional judicial review may not be able to deliver it if it permits the kind of reasoning in this case adopted by the Court of Appeal. And at all events, fourthly, this is the low intensity review encouraged by cases like by Pulhofer is not likely to be compatible with Article 6. And finally, utilitarian concerns about judicialisation are relevant, but don't stand in the way of any of that. And our background to this is that we, of course, accept that if you extend Article 6 to rights like those under Part 7, then it has to go hand in hand with limited review. But the point is that in the criteria for determining whether or not review is sufficient, and I simply make reference here to the relevant passage in Ali, which is at paragraph 78, reference is 641, that refers to the subject matter, manner in which the decision has been arrived at and the content of dispute. Applying all of those doesn't produce a binary option of you either have to have full fact-finding or you have to have traditional judicial review. But as a matter of logic, it must allow you to have something in between. And indeed, there are some authorities that suggest that Article 6 may shape review in that sense. And I refer you to the judgment of my Lord Reed in King, which is Volume 5, tab 67 at 1885.
We've all been rather thrown by reference to King. I think we know it as Burgas.
Yes,
Mr. King.
And in fact, it appears as Burgas in the report.
It had dropped out. Mr. King had dropped out by the time it reached us.
Well, it's not unknown that litigants live on in that way when they move out. But then in Q and and then in Q, which was the Section 55 case, the Lord Phillips made the same point.
Lots of us have said things about this, but what I don't quite understand is how it makes any difference in this case, where we have a fairly discrete issue about whether he got the law wrong in the particular way we've been discussing.
Well, our point is that, and as I've said at the outset, conventional judicial review is good enough for us in this case, and Article 6 is consistent with that, and we only need to rely on this if there's in some sense a mismatch, and the way in which we say a mismatch could arise is that the object of Article 6 requires that and again this is Ali, paragraph 79, whether the adjudicatory process as a whole has provided a due inquiry into the facts on the fact of that case, because that was the dispute in that case. And if the reviewing court, it follows, is part of the process of determining rights in accordance with Article 6 and has to ensure that that happens. And if the judicial review it may produce a different outcome because it starts from a slightly different starting point, which is that it's concerned only with legality, and a paradigm example is not investigating the facts. Now, normally the two will converge because judicial review is more flexible and review by a court of full jurisdiction is more restrictive. But there is room for a gap in the middle. We don't say it arises in this case because we say that the common law is adequate. But if you're against us on that, then Article 6 requires it. In this case, because otherwise there simply hasn't been an adequate investigation into the facts. We don't know what the reasoning process is. And the Court of Appeal has used different reasons to support it. And finally on this point, and we've referred to Pulhofer, the extremely restrictive approach in Pulhofer, we say, is not consistent with the due inquiry into the facts requirement in Article 6. And one can test it perhaps in this way by asking, well, what happens if you transplant the reasoning in Pulhofer into one of the Strasbourg cases? So, for example, in Ali, Ali sets out some of the grounds for judicial review and doesn't comment one way or the other on them. But if, for example, one put into there a test that was that one can only intervene in the most exceptional circumstances, or one can only intervene where a finding is just barely conceivable, then it may well be that Strasbourg would have taken a different view. Now, maybe it's not something that this court should express, feels the need to express a view on, but what we would certainly suggest is that it wouldn't be right to say that, whether or not Article 6 applies, that Article 6 will always yield the result, that conventional judicial review is sufficient, still less a Pulhofer-type judicial review. Would you bear with me a moment in case anything?
Of course.
Yes, our references in the Pulhofer case, are in our case, a paragraph
in your
141.
written case, yes.
The only other point we'd make in relation to Pulhofer, and this is my last point, and it's a point we haven't picked up in the case, but it's something that comes from my Lord Newberger's point in Holmes Morehouse, which is that one part of the statutory development that undermines Pulhofer is the fact that the county courts are now a first-tier appeal, and that then limits the scope for further control. But that, unless my lords have any further points.
Can I just ask to clarify one point which I should possibly have asked Mr. Baker? is there a reference somewhere in this Act to having regard to general housing conditions in your area?
Yes, there is.
Where is that?
It's in the definition of homelessness and whether it's reasonably continued.
177, subsection 2.
Yes, I don't know. Oh, that's fine, as long as I got the reference.
Thank you very much.
Thank you.
Thank you.
No, there's nothing else.
Sorry?
No, I was,
Thank you very much indeed.
no, I think we're just...
Mr. Sheldon, you were quick and you didn't have an opportunity to deal, as you might have expected to, with points that Mr. Westgate made. I think the fairest course to take, not to encourage you, if there's anything you want to say, you can say it briefly. Mr. Westgate should have the last word there. And if there's anything you want to say arising out of what's been said, you should have the opportunity.
My Lord, I have nothing further to add.
Consistent with your economic way of dealing with matters. Thank you. Well, we're very grateful to all three of you for your oral submission. Thank you very much indeed. And they have been much assisted by the full written cases you each produced, for which we're grateful. We will consider this matter and let you have our decision in due course. Thank you all very much indeed. Court's now adjourned.